Hi. So, what is the remedy in a check bounce case if at all the accused is taking the plea that the complainant made an advance to the accused by way of cash, which was above 20,000, and it is a direct violation of Section 269 SS of Income Tax Act. In such circumstances, if at all the complainant makes a payment to the accused by way of cash, which is above 20,000, and the accused in return issues a check for the repayment, but doesn't dispute the check, but doesn't dispute the signature on the check, but doesn't dispute the writing on the check, but doesn't dispute the issuance of the check, doesn't dispute the bouncing of the check, but disputes that Section 138 of NI Act will not be applicable because the expression the legally enforceable debt is not met with, as the complainant made the payment to the accused by way of cash, which is a violation of Section 269 SS of Income Tax Act. If that plea is taken by the accused, as his defense, will it sustain the rigor of Section 138 of NI Act is the question which we are going to understand right now. Supreme Court way back in 11th January 2008 rendered a decision pertaining to this question in the case that was before it between Krishna Janardhan Bhatt versus Dattatreya Hegde, rendered a decision on this question dated 11th January 2008, acquitting the accused. So the decision went against the complainant on the ground that because the complainant made payment, admitted that he made a payment by way of cash to the accused, the High Court failed to note that fact and passed a decision, and Supreme Court reversed that decision, acquitting the accused. Now I will explain what is the reasoning of the Supreme Court, Honorable Supreme Court, in reversing that decision of the High Court and allowing the SLP resulting in the acquittal of the accused. Now, legally enforceable debt or liability. What is legally enforceable debt or liability? That is a debt that is due from the accused on the basis of an amount that was given by the complainant to the accused through law. That is to say, it has to be a legally enforceable debt. No doubt, accused received the money. Admittedly, accused received the money. Complainant has a case in a civil court, but not in a criminal court, because the violation of Section 269 SS of Income Tax itself is a statutory violation by the complainant. Maybe the accused might have known that fact, or maybe the accused might not have known that fact at the time of obtaining the loan from the complainant. But the fact remains that complainant violated the law. Now the complainant is coming to the court with unclean hands. Now, if at all court decides that question in favor of the complainant, then court is allowing a statutory violation or in favor of the complainant. If at all court is allowing the complaint, now court admittedly is allowing the act of the complainant, which is illegal as per Income Tax Act. It may not be relevant to the Section 138 of NI Act, but it is very much relevant to the Income Tax Act. So therefore, complainant is coming to the court with unclean hands and therefore not entitled to the relief. He may have a remedy elsewhere in another form, in another court, civil court probably. Even there also this question will come for discussion. Because nobody cannot obtain a relief from the court. It is a fundamental principle of law that nobody cannot obtain a relief from the court with unclean hands, approaching with unclean hands. Complainant has to be fair enough in all aspects. At least the aspects or the facts which are visible to the naked eye. The facts or the aspects which are pleaded in his complaint. At least to that level, complainant must be fair to the court, which was not in the case which I informed earlier. Therefore, if at all complainant makes a payment to the accused by way of a cash about 20,000 and Income Tax Act 1961 is still in operation, it is ex facie offence, commission of offence by the complainant, and complainant cannot file a check bounce case with reference to the Honorable Apex Court's decision in Krishna Janardhan Bhatt versus Dattatreya Hegde, rendered on 11th January 2008. This decision is very much relevant to the facts of the case which I am explaining right now. Thank you.